All right, we are back on the record. It is 1:01 p.m. State versus Brooks appearances as far as they were before. I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections. No. If you would like to go back to the that you may not, I'm not sir, forcing you to go into their courtroom. It is a new part of the day. I thought it appropriate to have it brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
Are you going to address the matter of jurisdiction for the record, or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven. You
Objection
have
is
to state, can I go back to the court? Because I'm not going to do this with you.
Mr. Brooks, I do want to go over
We don't have.
jury instructions.
I don't understand the
verdict.
jury instructions. I don't understand anything that's in these procedures, and I'm not going to participate in something that I don't understand. Now, please go back to the.
You can, based on your choice, your request, I
I enforce anything.
understand that, but I feel
enforce
it's important to
anything.
also make a finding based upon your conduct.
Based on what kind of me asking?
Are you willing to expressly waive that right?
I'm not going to express anything.
Are you willing to
I'm
engage in a colloquy right to be present and a knowing and intelligent voluntary waiver of that right?
I'm not going to say anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the courtroom.
Again, say now for the record, I will not answer or come anything I do not understand. I'm not anything.
Are you willing to be that if I have to stay in the courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand.
Are you willing to interrupt proceedings with disruptive behavior?
I do not understand the questions that you're asking.
We'll give any questions directly. For now, he is to remain in this courtroom.
I'm requesting to not be in the courtroom.
But you go through, you won't answer my questions regarding that, sir.
I told you I don't understand.
Answer the question.
You asked me a question, I answered it. I don't understand. I answer something that I do not understand.
Right. Let's start with the
You're gonna start with,
I
you're gonna
would
start
like
with matter of jurisdiction
to decline that already, sir.
under lawful law.
Please do not interrupt with the subject matter jurisdiction or you run the risk of forfeiting your right to be present in the courtroom.
Going to the courtroom.
Are you willing to engage in that discussion? Sir? I need to make it appropriate.
I don't understand what you're asking. Do you want me to do? Answer.
You're choosing to answer that.
I believe what you believe. I believe that you hide stuff from the area. I believe you're in warfare. You enter into this do something. But it doesn't matter what we do, Your Honor. I'm a request to not be I cannot answer question you're asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand anything. I don't understand.
you're going to stay here?
Under what lawful law? You can't make you can't make me understand. You can't make me force me to understand. Force that.
I need to address one of the instructions. Number 13.
I'm trying to make a request to not be present in these matters with disrupting that I do. And we're talking as you say that I do. I'm making a request for me to not be present for obviously I'm not needed because every decision that's been made here today has been made by my consent. Clearly telling me that I'm not needed. I never consented to anything that's on here today. I haven't been allowed to present evidence, which I did weeks ago. Weeks. Your Honor, that I want to present into evidence. I've asked numerous times for that and been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions that the court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present for your testimony and evidence through other witnesses, and then you forfeited your right to testify on your behalf. I'm not going to revisit those, sir.
I asked you to revisit them. They weren't.
I understand
Because I never consented to, I never answered something. And the reason why I didn't answer because I understand, not force me to understand what you're asking me.
Sir, I could not even get through to even listen. You talk over me repeatedly.
Because I've been all morning. You sent me to
I did.
right. So I've been over there all morning.
An adequate visual system.
It's adequate. And it's not. It's how you always think that, but it never refers to the option that you refer to. It never.
This way, if you bring up something.
I didn't bring
that I made earlier.
I'm trying to figure out why I'm being held in contempt.
Frustrating the purposes of this.
I'm trying to figure out why I'm being held
which
in
is final
contempt.
instruction in the verdict form.
I'm merely trying to. You never said to tell me. Where you go. Decisions, Your Honor.
I understand that.
You asked me questions. You asked me questions. I didn't answer back my understanding. How can you force me to understand what you're asking me? Don't. And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's I'm not
advising you
arguing
that
with you about what you wrote. I'm saying how can you do that without my
you continue to raise issues that I've already
that's a violation
addressed.
of my civil rights.
If you continue to raise these issues, sir, in court, the purpose of this court is to analyze the jury. You will forfeit in the courtroom. You will appear from the courtroom.
Okay.
Absent, I know you've requested.
I made a request for the moment in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue me about your
This is my Fifth Amendment right. Exercising my right that reserved from the moment we walked in here. You can't force that. You can't force me to do anything, actually.
You're right, but I forfeit rights of
And,
based on
for law, Your Honor.
smart. All right,
Right?
I am
That I
moving
can
on.
from another court.
Discuss
I
5. Language
understand.
needs to be modified based upon the court's ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you, really, Your Honor, that I don't understand, you can't force me to understand. That's right to try to force something. That's coercion.
Complete of the proceeding. While it is true to provide consent, you were
I did
cooperative with the court this week.
because I didn't understand. Explain why, Your Honor. I'm not
Court
trying to
gave
leave
you
it where it
ample
was at.
opportunity to answer the
I'm
questions.
attempting to
So
to
I go,
explain of why I'm not answered. It was because the way that you're making it is that I intentionally didn't want to answer, and that's not fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
If I'm telling
do
you I
you
don't
understand
understand.
what that I'm asking?
No, I don't. No,
Please stop.
brother, I don't consent to about that name,
You
Your Honor.
clearly, sir, because if you didn't hear me, you wouldn't make that statement.
Hearing
I
and
know you can
understanding
hear me.
is two different things.
I know you can hear me. So
Understand.
I'm bringing up instruction 315. You can't say that if you haven't heard what I have to say. I need to clarify something because the title not to testify. In there, however, that instruction should only be given if requested by the defendant. There has been no request made. And this court made a finding that he forfeited his right to testify. And applicant Brooks requesting instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. This is a state position on that.
You get the note associated with instruction 315, I would agree.
Right. Mr. You have a position on whether this court should include instruction 315 in the instructions to the jury.
I don't even understand what 315 is.
Titled Defendant elect to testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says begin only if requested by defendant, and it reads as follows. This is the full language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and not influence your verdict in any manner. The question is, do you want this instruction read or modified in A?
You just said I got the constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In the other case, that a decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision? I didn't.
My question to
never say
you
yes
is,
or no. I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any
Right. because I
this
don't
instruction.
understand why you're asking the question. I never decided to or not to testify. I never decided.
I understand that.
So I don't
At the moment, we're discussing whether the jury should receive instructions not irrespective of the reason for that. I believe I can modify this instruction to simply say silence or defendant not testifying should not be considered by the jury in any way and must not influence the verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to not testify.
I understand what you're saying, sir. I really do. But in light of the court's decision, do you want the jury to be instructed on the fact of cannot use your silence, meaning they cannot use you not testifying against you in any way?
I understand the decision to or
Ask you one more time, and if you do not answer with a yes or no, I'll take your answer of not answering as you are not making a request for a modified action.
how can you do that?
Do you want all right.
No.
Mr. Brooks, as it's standard pattern this court has suggested 3 is taken out of the jury instructions. Then I have looked for I would describe and how is I want to be consistent with how I spell it. Homicide or safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document of that nature. It's my practice, and you should be aware, Mr. Brooks, that I always put not guilty next top when I hand all the verdict forms to the jury. And by that, I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for count through 76.
You said it's collated. What do that mean?
So not guilty and the guilty followed by the not guilty for 2 and through total.
I don't understand.
I looked at the special questions.
Were you answering
Only they did appear things, but I believe those are all accurate. To the state.
Since you have to answer any questions, but I have to answer all, can I go to court?
Not at this time.
Why not? I don't understand anything.
You can look
Please.
you wait.
I'm making a choice.
No.
So what? You gonna try to force me to do all this so you can make the record
Sir, I'd
and
like
make
you
it
to
seem like I forced something that came in here. We got on the record and made the request to not be present for these proceedings. Make the request. So avoid drama and all that.
Sir, the only one with the drama is you.
You make
I have questions in
I've been saying that since we came here.
Mr.
You can't
respond
force me to
as follows to
understand.
that. You waived your right to counsel.
I didn't waive my right to no counsel. I gave you the
waived your
contract.
right.
I did not. You won't sit here and say that for the rest. That is not
No,
what happened.
you are
No.
incorrect.
So we don't have the. Do we have the paperwork? Because I believe I gave you the paperwork that you.
Mr. Brooks, you
I gave it to you.
clearly
It did not waive it.
have been presenting nuanced argument
That
the
is
right
not
to
true, Your
counsel.
That is
A pretty sophisticated argument. I believe you fully understand what's
I
going
don't.
on in this court.
hopefully you
I
understand.
disagree with your characterization of the right to counsel. You
I
waived
gave it to you. If you question me, I'm telling you right now, you still won't even acknowledge what I'm saying. It's on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to. I explained I did not, sir, because I didn't understand. Which is my right to say that.
All right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering
Amendment
with the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not. Continue to
You
interrupt.
said waive. I'm
Here until I you forfeit.
which is at some point. It's biased. It's judicial misconduct.
I see the goal of this trial.
So you're reading or are you just slightly
Number one, sir, is during the evidentiary phase of evidence.
not
When the case has truth. There's been, but secondary to efficiency has been my repeated use of that would fall under the goal of everything I've done here, and that is the courtesy and decorum in this court. Responsibility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
how have my rights been protected?
With sir,
Yeah, but how can
in a,
I defend myself even with evidence?
but sir, you are willing to follow the rules.
But that doesn't
Mrs.
have
Fryer, it has
You did
everything.
that from the other room too, correct?
Sir, you
I can listen from the other courtroom. I should present evidence from the other courtroom.
and you, by your conduct this morning, sir, not
I'm
answer
saying-
the most questions
The
about
totality,
whether
the
you
totality.
had
Have I
a
not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I asked more than once?
You have not asked evidence
Yes, I have. You
in
told me we did
a manner.
Why would I? If you didn't answer
You,
the
as your own, you need at your own times.
that
Whether you
has
have full
nothing to do with me
understanding
presenting
of
evidence.
procedure and rules.
Present evidence.
Mr. Brooks,
It
morning
happened to be admitted
for discussion of if you interrupt them again, we'll make a finding that you right to be present, and you will appear from the neighboring courtroom.
You want me to hear from the neighboring court? Let's
I don't.
just let
Go ahead.
just let me go. This is
Clerk.
ridiculous.
He's interrupted. His right. Despite the court will be in.
Ask. Understand. No, you don't have to do this. I do it.
Mr. Brooks is now appearing from the other courtroom. Appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Casey, you can complete your record.
For count 15, not guilty verdict, I didn't have a guilty verdict, but the way that it was on the paper, immediately, that's and I think you have it packet, it just didn't get coffee.
We'll make sure it's there. Any misspellings of names?
I did not see any.
All right. Did when we started up the video conference, Mr. Brooks has been muted. I'm going to unmute him right now. And I should state again for the record, all of the forms were permitted to him prior to the lunch break. So you have had an opportunity to review. Should have chosen to do that. Do you have any position on the verdict form, sir?
Now, just yet to prove the record.
The verdict forms, what you did.
Again, I haven't been provided with anything.
They were provided to you for the lunch
I
break.
haven't been provided with anything.
Teresa, you had a large packet of verdict forms. What were they given to?
Questions here to the out of the Colorado
Mind you,
shooting
once
at a
again,
criminal
practice
WLS. Following this presser, the attorney holding the news course will also be
of and have the special verdict questions. Those verdict questions only as they relate to guilty verdicts related to the use of dangerous weapon counts. 1 through 6, the homicide counts, and then 61 through I believe 60.
It would be 7.
There's 7 through 67. That special verdict count as the related to the counts involve the death of a person that names the person alleged to have been killed. So those look to be in order. I've already addressed going back to the jury instructions 315. We have done a little bit of rearranging some of the but content is there. It is my practice to read through all of the instructions up until the point of closing arguments. And I stop, given their opportunity to argue the case to the jury. Following that, there are the I like to call the closing instructions, are still lengthy in this case, and that they go through the verdict form specifically. And then, of course, the alternate jurors would be selected. Given.
Am I muted?
No, you're not. You haven't been.
So I got a question about the
endangering safety.
So what that
Correct. You asking how you
that's why
part of the, I'm sorry, part of the statute you referred to. Just what again?
how
With state apply use to use a dangerous weapon is an essential element of the charge.
charge. That's what I'm reading.
Well, what's the state's response?
Using possession of either homicide or injuring safety, or it would be a jury instruction. I can see this is a situation like armed robbery requires the use of a dangerous weapon. And it's correctly those two types of crimes.
Comment on that, sir?
Where's the problem?
Argument. I read this and looked at the element for intentional homicide and first degree endangering safety. Either one of those crimes has an element in it. Use of a vehicle. There are certainly many ways that both of those statutes can be violated. While it's true that in other case the use of the vehicle is or instrumentality that's being alleged and used, but it's not as being an essential element of the crime. Robbery crime example of when you could not face an enhancer for use of a dangerous weapon because of the crime or use of a dangerous weapon. And so
that's the same argument in this, Your Honor. You can't have this alleged without the use of the vehicle. It's the same thing.
it's not an actual element of either first-degree intentional homicide or first-degree endangering safety. So I'll deny the request to strike the enhancer for those reasons properly before their determination.
Reconsider.
Deny.
For the record, I move to this matter is court of common jurisdiction,
Your request
the law or fact.
based on our facts, sir.
Consent.
The court's finding information is noted. I decline to issue any type of written decision or stay pending appeal. Noting there is no appeal that has been filed. It's already its findings regarding the forfeiture to testify and the forfeiture of the right to present additional evidence and testimony. I'm not going to revisit the same.
Which was not consented to. I never.
I understand.
Decision you made when I didn't understand the question being answered.
Sir, do you have any other questions or issues?
Your Honor, are you making a judicial determination that you don't answer any questions?
I'm not answering those questions, sir, on how I already answered them.
Is that a judicial determination?
Sir, every decision you make is
Is
any
and I
to
will tell you
raise-
I don't understand the question.
raised with respect
I do not.
has now answered the question. One time specifically, as that is failure to answer the question will be taken by the court as a no. Sir, do you have any additional?
Under law fact, can you say no?
Do you have any additional issues to raise with respect to forms?
I do not understand that you are asking.
All right, he has chosen not to answer by saying he does not understand questions. He didn't specifically answer yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is incorrect. Man, you can't force me to understand something, Your Honor.
All right. Do they have any? I'm gonna mute Mr. Brooks. I'm moving on to another topic. Understand you disagree with the court's rulings. You need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again. Follow exercise my ability to ask you. Does the state have any other as it relates to the jury kind of full circle back to that because I do need to approve them.
Yes, we do not.
You the same. I will. Question. Momentarily, sir, I will ask one more time if you have any requests as it relates to the jury instructions. Then I'll ask you to approve jury instructions. If you do not answer questions related to do you have any requests to the jury instructions, I will interpret that as a no and do not specifically about the jury instructions. I interpret that as yours. So, first question to you is: do you have any, and you're unmuted, have any requests at this point as it relates to the jury instructions?
I just said I do. I said I don't understand the question. That question I don't understand.
Any requests for any instructions that are not answered or included? Instructions you have.
Ago.
What are you referring to, sir? If I've overlooked that, I will certainly consider, but I'm aware of a specific jury instruction.
Like you overlooked a lot.
Can you point me to a specific filing?
So you have my filings on. Are you have?
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instruction.
You just said you was referring to the file, right? You said it.
It's not.
Are referring to instructions. You or did you not?
Do you have a specific filing you can report to that relates to jury instructions?
Is your computer working or is it not working?
It's being a little, but I have. I just search. That would be great. The court does not make it the evidence of the trial or rules of procedure and evidence that govern that.
And
It's what it's not my advocate your behalf. If you particular sir, a specific task, now is the time to make it.
I don't said those instructions.
Jury instructions were due on August 30th. The state submitted their proposed instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I believe that there's been a request for 8 different juries than what have been.
As then you request that they all be responsible. Not us. During the registration conference, the record after I will look for grammar to make sure that it's correct, and provide a written printout of the final draft for the parties before we break for the day today. I am also of the statement.
I don't get 16 name, and I've just told you I don't understand you. Just because you feel
No, that is
one of
his,
those just for me now. How's that fair?
this court gave you draft of the jury instructions. I need to mute you because once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdicts printed off and provided to both the state and Mr. Brooks. It is also true that when he was previously represented counsel, the court had some specific deadlines related
Deirdre at ABC on Channel 3 right now. We're expecting a press from
regarding
at Chicago, source of wls.
from the state.
Channel 4 is the president and the first lady at the South.
Other filings, but I could not find anything related to instructions, specific requests being or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. Again, before we break for the day, we'll make sure to provide the parties with written printout of both of the documents as they now stand. And there are a few other issues we need to go through. I think the think it was the alternate sequestration and might have been a third.
Sure. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the 3 alternates once they have been selected. It would be our request position that they should remain in a secure location, set apart from anyone else until full deliberations are given by the 12 to decide the case. So if needed, and the COVID issue we have on this, if one of the alternates slide into a position of one of the 12 deliberating, that became for arguments, verdict returned by the jury, and then the court's intention as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you want the court to address? You have been unmuted, so you can answer that. Mr. Brook, any of those final type of questions, issues you want the court to address? Are unmuted.
There's nothing I'm with the truth.
Mr. Brook, closing argument, correct? Well, state will object when appropriate.
A lot of objection. And a lot I understand decisions based on my behalf without me
Are you telling me that you will refuse to follow the quorum, the civility, the rules of evidence,
don't try to
the
come
rules
with
of procedure?
don't try to
Sir, I am being slick. I'm trying to
You-
integrity.
wait.
All right. I'm going to choose, sir. What you're saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I need to over these. All right. I'm asking him because I need over these important issues that have been raised by this. So as far as the arguments, I do think it is important to keep alternate location overnight unless and until in this matter will court to make those arrangements. We've been long in any event. As far as selecting the alternate, obviously jurors have a number. I intend to have equal size pieces of paper made, folded up with each jurors, put them in the same turtle bin that we utilize for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those would be the alternates, and the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As indicated this morning, all of the jurors were provided with information. Sequestration is a practice that I've approved in the case that the jury certain emergency content, so should there be need for giving information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case, so that I know what was the jurors today before they left. And then I'll also make sure that the 12 deliberation that the 3 are taken to a different room with bailiff in a secure location. But from the other 12, we need to take up that at that time. Good practice available if it comes to be back at 9 a.m. Typically, we have a few things to find in the morning, so we'll start at 8 tomorrow morning. It will also give the parties one final opportunity to read through many jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed for tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on 107 pages. Some of those pages, though, are after argument, and so that really kind of begs the question. Make their arguments. Check my seat, but far. Okay, thank you. Single side. Given so the instructions that I read to the parties giving the closing arguments finishes on page 73. Given that, I believe the parties will be able to give their closing arguments tomorrow. It just may be depending on what the final instructions are given. Because under 30 pages, I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations if that's what needs to be done.
Understood, and we'll be ready. I think from our record, it took you about 2.5 hours to read the preliminary instruction, which was 69 pages in length. So the folds, I think, we reasonably could do closings in the afternoon. Probably do about an hour to read those remaining 30 pages, and we may still be able to wrap up by 4 or 5 o'clock in the court.
I think it's a reasonable from any estimation on the length of your closing. I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range. Just
reasonable our total initial
Just a ebook.
can't disagree with you there.
I'm glad she lived by it. Anyway.
Most likely be forfeit your right to give one, sir, because
You can't force me not. What type of jury were you? How's that law?
sir, if you choose not to give one, if you choose not now, disrespectful once again.
Okay,
You didn't even let me get. You because clearly he just wants to disrupt this. As we have been talking over the course of the last 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, with what read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all the first part of the instructions. Then the state will give its closing argument, giving the parties 1 hour. I think that's circumstance. Initial closing arguments for rebuttal, and following the state, a break of some sort, probably before the document closes, just for the jury's sake. It will need a comfort. You go myself, and I'll have my make sure after the time we'll read instructions. In the jury's want to start deliberating, that's fine. You know, if it's 7 o'clock at night, I'll probably tell them break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That will be Wednesday morning. But there's, now that I really kind of laid that out and thought about the break, I will have with pages tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you. That is the expectation of the court, that the arguments will be done tomorrow.
You can't read or you can't
Actually, under all the rules of procedure, it is my job to make sure there's effective and efficient administration of this trial.
I'm allowed to, then if that's the case, to be allowed to when they know that they have the power to
Ready to go and raise the sir. You have no right. That is sir. his closing, an unfettered right to say whatever he wants, how he wants. If he is going to be asked about defining rules, tell them part of it, that is very by his they walk in behind me. I don't want him to look worse than what he's looked frankly in front of this court when they haven't been in this room. I need to preserve looks to this jury. And I will need a very clear plan that will follow the rulings that I make as it relates to the closing arguments. Cannot raise jurisdiction. He cannot, that are not part of the facts based upon theory, based upon the evidence that's been presented. If he's going to, I can only imagine there may be some objections by the state. If there's an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I submit an objection, he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure, rules of evidence, then he will be in the courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks at jury. That's the sure this jury makes sense and do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They're not be concern themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you have to follow. And like any other time in the trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And I put that as you are squarely put on notice of here today, sir. With that, I've addressed all of the issues the state has any to. Oh, one other issue: verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. Maybe news media, in fact, that may want to cover verdicts. And this jury will take some time due to the sheer volume of counts in this case. Once court is advised that verdicts have been reached, I am contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But it will depend on how at night, during the day, we're dealing with any kind of traffic issues. I realize in the area that may want to be here as well. Even if I consider, the areas of Waukesha, you could be as much away. So that's my initial thought on that. any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
That's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdict was if you intended to maintain the designated benches for the reasons you just said.
I wouldn't keep it as is.
Okay.
The
Reserve
entire behind the state for victims.
side, reserve for the first 5 minutes, or is that open seating over there?
Sir, my rule 15 minutes. What I would say is any open seating in the courtroom, it will still be open the whole time because it has to be. So it's left open 15 minutes. Victims could also sit on the other side,
Okay,
if that's what you're asking me.
yes.
All right. Mr. Brooks, any further topics by you? No. You're Sir, you can forfeit number of conduct. The Chambers versus City. Arkansas. State versus Anthony. Illinois versus Clinton. Case law. Simply miss. So, to address,
I'm sorry.
I'm sorry. Go ahead.
Reflect that and the Mr. Brooks immediately turned and dropped them to his left off the side of the table. I can't tell if it's trash or not, but I did see that after he another thing.
During instructions. Just during instructions, but some of the things.
Okay,
They were-
and gonna make.
Yeah, I'll get Lauren down here right away, make sure Lauren Brooks is to the cell. In a second, that he's.
All right. I don't be this. This matter should be in this case. You intending to proceed or
How if we have time, I would certainly consider that. I mean, I've hasn't set yet, and I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. To know from both the whether they anticipate any leaking other than the parties themselves. Any family members?
Yes,
I
we-
don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get to you. I'm unmuting you. Go ahead. You're muted.
We're all
your